हेलो सावल। हेलो।
यस सर।
मेरी आवाज इको तो नहीं हो रही है?
इको
सर
नहीं
प्रॉपर आ
सर,
रही है।
सही नहीं,
हैं?
सही आ रही है। यस, प्रॉपर आवाज आ रही है सर।
ठीक है, ठीक है, ठीक है। ठीक है,
नहीं, सही आ रही है बिल्कुल नहीं।
ठीक है।
उसका थोड़ा ध्यान रखना है, इको का ध्यान रखना है सर। आज थोड़ा सा साहब का मेल भी आया था, मैसेज भी आया हुआ है।
हाँ, हाँ, हाँ।
वो थोड़ा क्या बीच में इको का प्रॉब्लम होता है, तो जो जिनको म्यूट करना है केवल, मैं कहा जो जो बोल रहा है ना केवल उसके अलावा बाकी सबको म्यूट रखें तो ज्यादा बेहतर रहेगा।
हाँ, मनजीत सिंह जी, ये ध्यान रखना यार।
हाँ, स्पीकर जब स्पीकर बोल रहा है उस समय बाकी सबके म्यूट रहने चाहिए, मतलब ये है।
हम्म। घर पे वो नंबर आता है ना, कितने लोगों ने फोन किया।
हाँ, गुड मॉर्निंग सर।
हाँ जी, गुड मॉर्निंग सर, गुड मॉर्निंग।
यस सर।
वो मैंने दे दी सर किताब, बुक उसको।
अच्छा, ठीक है।
लेके आ ही रहा होगा
हाँ,
वो। 35 लोगों ने अटेंड कर लिया क्या? सर, साढ़े तीन
हाँ।
सौ रजिस्ट्रेशन 350 रजिस्ट्रेशन हो चुके हैं मेरे पास।
अच्छा, ठीक है, थैंक यू सर, ग्रेट। अरे
कल
ये
गूगल।
वीडियो आ रहा है सर?
हाँ, बिल्कुल आ रहा है।
ओके सर।
आवाज भी आपकी बिल्कुल क्लियर आ रही है।
ठीक ठीक ठीक।
Good morning, sir.
गुड मॉर्निंग, गुड मॉर्निंग। सर सर, मॉर्निंग सर, एक बार 10 बजे ज्वाइन कर लीजिएगा सर, है ना? बस बस। हाँ, बस। ठीक 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 है सर, ठीक। ठीक है सर, ठीक। थैंक यू। हाँ साहब।
गुड मॉर्निंग राजन सर। राजन सर।
राजन सर, आवाज आ रही है आपको मेरी? हेलो।
हेलो राजन सर। राजन सर, आपका माइक्रोफोन प्रॉपर नहीं चल रहा है।
आपकी आवाज देखिए सर, टेस्ट करिए, आवाज नहीं आ रही आपकी।
सर आपका माइक्रोफोन में प्रॉब्लम है, तो इसलिए माइक्रोफोन हटा के या वापस चेक करके यूज करें सर।
कर रहे हो, कर रहे हैं, देख रहे हैं। हम्म, अच्छा
उस पर लिखा हुआ है AKM। नहीं, वो कोई सेमिनार में गए थे तो वहाँ लिख दिया था उन्होंने। ओके।
माथुर सर।
यहाँ सर।
CR मेहता जी और इनसे बात कीजिए ना सर, ज्वाइन करें।
हाँ, CR मेहता साहब ने कहा था, का मैसेज आया कि आई विल ज्वाइन इन टाइम, मैं करता हूँ फोन।
हाँ, उनसे भी करो। और ये अपने यशवंत जी।
हाँ, यशवंत जी की कोई मीटिंग चल रही है, उन्होंने कहा मैं ज्वाइन कर लूंगा।
ठीक है
Hi,
सर।
can you hear me now?
या।
Great. Okay, I'll minimize the screen so
Sir,
whenever we
welcome,
have
sir.
a session, I'll log in.
या।
Okay.
वेरी गुड मॉर्निंग HVC सर।
हाँ, गुड मॉर्निंग, गुड मॉर्निंग, गुड मॉर्निंग।
गुड मॉर्निंग।
Good morning, sir.
गुड मॉर्निंग सर, नमस्कार। हाँ, नमस्ते जी, क्या हाल है?
गुड मॉर्निंग सर। गुड मॉर्निंग सर।
मॉर्निंग
गुड
सर।
मॉर्निंग, मॉर्निंग सिंह साहब, गुड मॉर्निंग। यस डॉक्टर माथुर, SM माथुर साहब, क्या हाल चाल है?
बस सर, बढ़िया सर, एकदम।
Good
एक
morning,
मेहता
sir.
साहब का फोन आ रहा है। हाँ सर, ज्वाइन कर लें।
Good morning, sir.
Good
Good
morning.
morning, good morning,
Good morning,
good
Mehta
morning,
sir.
good
Sir.
morning.
गुड मॉर्निंग सीआर मेहता सर।
Good morning.
गुड मॉर्निंग
अच्छा,
मेहता
मेरा वीडियो नहीं दिख रहा है?
हाँ, वीडियो नहीं दिख रहा है मेहता साहब।
नहीं, चालू कर दिया अभी।
अब आ गया।
गुड मॉर्निंग मेहता साहब।
गुड मॉर्निंग, धन्यवाद सिंह साहब, आप उस दिन
हाँ।
हमारे साथ ज्वाइन किए।
हाँ, बिल्कुल बिल्कुल अच्छा रहा, प्रोग्राम काफी अच्छा था,
हमने
बहुत अच्छा प्लान
कोशिश किया था, लेकिन ठीक रहा, जो सोचा था उससे बेटर ही रहा।
नहीं, बहुत अच्छा था। ये अच्छा, इस तरह के फार्मर ओरिएंटेड प्रोग्राम होते रहने चाहिए, वैसे काफी अच्छा इसमें
हाँ, नहीं, आजकल
लोगों को।
प्लेटफॉर्म भी अच्छा मिल गए हैं, तो इजी भी
हम्म
हो गया ऑर्गेनाइज करना। पहले लॉजिस्टिक में बहुत एनर्जी लगती थी।
लगती थी, सही बात है।
डीआर साहब भी ज्वाइन कर रहे हैं, उनके थोड़े से स्क्रीन में प्रॉब्लम हो रही है नेट पे।
राठौर साहब कैसे हैं सर?
बस बढ़िया, थैंक यू, थैंक यू।
नहीं, तो आपको धन्यवाद, आप हमें बुलाते रहते हैं, और हम सीटीआई के नाम पर बिल्कुल कभी मना नहीं कर सकते।
नहीं, थैंक यू वेरी मच सर। उसमें तो
हाँ, नहीं, अच्छा लगा आपने टाइम नहीं दिया, दैट इज गुड।
नहीं सर, धन्यवाद। ये तो खैर एफआईएम भी इन्वॉल्व है इसमें, तो और भी मेरा राइट बनता
हाँ
है,
हाँ
मुझे ज्वाइन भी करना चाहिए।
हाँ जी, हाँ
नहीं, अच्छा है, आप काफी एक्टिविटीज करवा रहे हैं आप, मैं देख रहा हूँ यूनिवर्सिटी की। खासतौर से फेसबुक पर उतना एक्टिव नहीं हूँ,
हाँ
लेकिन कभी कभार नजर जाती है तो देखता हूँ।
हाँ, नहीं ये सब यही कर रहे हैं, मैं तो क्या कर रहा हूँ, सब माई स्टाफ ऑल आर वर्किंग हार्ड टू मेक दिस यूनिवर्सिटी ऑन टॉप पोजीशन।
एक
जैसे
आपने अभी कोर्स भी
गाइडलाइंस
शुरू
आपकी
किया
है
है
ना
ना,
सर।
एआई पर कोर्स शुरू किया है।
Yeah, we have designed and we got it approval from all possible corner. From AICT has also approved. Our board of management has also approved. State government has also approved. It is
That is,
AI and data science.
yeah, that is very good. Actually, everyone is talking about that, and there is no course. Everyone is learning from some other sources.
Yes, yes. And especially our 3-person, they really deserve appreciation. And of course, President Dean, he is also main instrumental behind it. Otherwise, Dr. Sunil Joshi, our head of the department from electronics, Dr. Naveen Chaudhary, head of the department of computer, Dr. Rajesh Sharma, and Dr. P.K. Singh. They are responsible person. They have nicely drafted the syllabus. That is a unique thing in this case. Personally, I have gone through and I was not having any scope for further improvement. And yeah. Otherwise, this is my tendency to see always to find out what are the scope of improvement. But unfortunately, I could not get any scope for improvement. That was an unfortunate part on my side, but everything was in such a good position. And this data science nowadays, it is not only being required by a professional, but students are also being attracted towards this. And many students, they are asking. And when I have floated this idea,
Thank you very
I
much.
have sent this. I have sent this idea to all vice chancellor. I have written a personal letter to each and everyone, and everybody has appreciated. I have received more than that of a 50% of my letter response, and everybody has given a very good rating of this particular course. Because nowadays people are talking about digital technology, but how far it is well known to general public and even to students, that is a basically a big issue. अच्छा कोर्स है, देखो अब कितना हम सक्सेस होते हैं। कई बार मेरा ये ऑब्जर्वेशन है, मैंने जहाँ भी कोई नया कोर्स शुरू किया है वो इतना अच्छा अट्रैक्टिव नहीं रहा।
हाँ सर, आपने
एक
हाँ,
मैंने पहले MBA शुरू की थी यहाँ
हाँ,
टेक्नोलॉजी में, MBA
इसको
टेक्नोलॉजी,
thank you।
LCT has appreciated।
अच्छा, पार्टिसिपेट
उसके
नहीं, but
बाद
it
वो
is
नहीं
having
ज्यादा
lot
चल
of
पाया।
scope, sir.
होता है।
It
हाँ,
because
it is there.
now it is
See.
need of the hour, and actually we also need trained faculty, those who can
Correct.
train others in this
Yeah.
area.
Yes,
At
yes,
our
yes,
institute
that is
also
true.
we are starting one department in this area. So that has already
हाँ,
been decided.
engineering institute, engineering institute में तो करना ही चाहिए। मैं तो I was always saying this, that who will lead this digital technology? Perhaps engineering institute will lead it. The engineering division should lead, not the
Yes,
educational division. I was always saying this thing when I was there in ICR.
Yes, sir. Yes.
And only thing is that engineering has got a number of activity. That's why they could not find a right space for this digital technology. And that is the reason why statistician has started some work as far as the big data analytics is concerned. But still things are not in the right shape. If we compare ourselves with other more developed country, we are far behind
Far
them.
behind here. But
Yeah.
now we have started
Let
number
us
of
see क्या
projects in
होता है।
this area.
हाँ, that is true, that is true. इसका कुछ अच्छा रिजल्ट आएगा तो डेफिनेटली अब सब हमारे बेनिफिट, मेन टास्क है हाउ टू एजुकेट आवर फार्मर्स इन दिस पर्टिकुलर जॉब। हम तो सब अवेयर हैं। As a scientist, I don't think that not a single scientist you will find that who is not aware about digital technology. But main important thing is how to communicate this message to farmer.
Actually now
Farmers
farmers
are
have,
still deprived of.
नहीं, लेकिन nowadays farmers have also started using smartphones. So slowly they will adopt. Even
That
some
is
of them have adopted
no.
remote operation of pumps using mobile and like that. So slowly such things will be
That
adopted.
is yeah. Future is definitely bright. We will have to find out
Good
different
morning.
ways. Good
जी,
morning, डॉक्टर साहब। हम आप ही की वेट कर रहे थे।
नहीं सर, थोड़ी कनेक्टिविटी
डॉक्टर हमारे डीआर साहब, हमारे डॉक्टर SM माथुर साहब ने कहा कि जब तक डीआर साहब ज्वाइन नहीं करेंगे तब तक मैं नहीं रन करूंगा।
नहीं सर, सो काइंड ऑफ
With your permission, now we can start, sir.
कैंटी में जुड़ गया था सर मैं।
हाँ,
प्लीज स्टार्ट।
हाँ, हेमो शुरू करो।
Yes, sir. Namaskar and a very good morning and hearty welcome to one and all present for the national webinar on challenges of intellectual property rights for innovation in agricultural machinery under the aegis of College of Technology and Engineering, MPUAT, Udaipur, by All India Coordinated Research Project on Farm Implements and Machinery and Package of Practices, Publication and Patent Facilitation Cell. We're delighted to have our most honorable Vice Chancellor, Professor Narendra Singh Ji Rathore, as chief guest of this webinar. On behalf of the entire organizing team and on my own behalf, I extend a very warm welcome to you, sir. We also have with us a special guest of today's webinar, Dr. C.R. Mehta, Director CIAE and Project Coordinator AGRIP on FIM, ICR, Bhopal. The distinguished speakers for the day, Mr. Rajan Alwadi, IPR Attorney, SIP Elite IT, Intellectual Property Council, Gurugram, and Dr. Yashwant Dev Pawar, Scientist and Head PFC of TIFEC, New Delhi, our own SOC members, faculty members, participating students, and others from various parts of the country. A very warm welcome to one and all. At the outset, I request the convener of the webinar, Dr. P.K. Singh Ji, sir, Professor and Dean CTA, to please deliver his welcome address. P.K. Singh
Thank
Ji,
you.
sir.
Thank you, madam. Honorable Vice Chancellor Dr. Narendra Singh Ji Rathore Sahab, Chief Guest of the today's program, Dr. C.R. Mehta Sahab, Director, ICR, Central Institute of Agriculture Engineering, Bhopal. Shri Rajan Elavadi, sir, IPR attorney from Gurgaon. Dr. Yaswant Dev Parmar, scientist and head PFC, New Delhi. Dr. S.K. Sharma Sahab, Director Research MPUAT, Udaipur. All SOC members of the university. Dr. S.M. Mathur Sahab, Organizing Secretary of the program. Dr. S.S. Meena, PI, HISA. All head of the departments and participants. I extend hearty welcome to our Honorable Vice Chancellor, Dr. Narendra Singh Ji Rathore Sahab, Chief Guest of the today's program, for this particular webinar that is on challenges on intellectual property rights for innovation in agricultural machinery. Sir, under your dynamic leadership and motivation provided to the faculty members and all of us, the university has achieved several milestones, and particularly I would like to tell two important milestones that our university has achieved. One is the starting of the new course of artificial intelligence and data science. This is the one of the important course initiated by our university, and out of the 74 agricultural university across the country, MPUAT is the first university who initiated this activity, and it started the course of the artificial intelligence and data science. One more milestone that was basically achieved by our university, that is the guideline development for intellectual property management. And our university is the pioneer university which has initiated and developed a guideline for the intellectual property management, and this guideline was recently approved in the board of the management meeting. After the joining of Honorable Vice Chancellor University, as Vice Chancellor as university, our university has achieved several milestones, and I would like to tell you that, sir, under your dynamic leadership, the CTA is also achieved a very good performance across the country and achieved 38 rank in the West Zone and 170 rank in All India rank, and it was nominated by the AICT. Our university has also initiated 3 BVOC courses, and these 3 BVOC courses are very important courses, and we are also going to launch one BVOC course, particularly on the software development. Sir, under your dynamic leadership, I assure you that we will work hard and we will also achieve several milestones in the near future. I also welcome my friend Dr. C.R. Mehta Sahab, Director, Central Institute of Agriculture Engineering. And Dr. C.R. Mehta Sahab is a well-known personality, particularly in the field of agricultural mechanization, and everybody knows him. We spent a lot of time in the hostel, also at CTI hostel when we were a student. And welcome, sir. Welcome, Dr. Mehta Sahab, in this program. I also welcome
Thank you.
Dr. Rajan Elavadi Sahab, IPR attorney, and Dr. Yaswant Dev Parmar Sahab, scientist and head PFC, New Delhi. Sir, I hope that your deliberation will be certainly beneficial to all of us, particularly the scientists working in the MPUAT for the filing of the patent. And I would like to tell you, sir, that during this year, our faculty has taken the patent of 6 patents of the national and international repute. And I hope that with your deliberations and with your motivation and support, the faculty will come forward, and also they will find number of the patent with your motivation and the support. I also welcome Dr. S.K. Sharma Sahab, Director Research of our university, and all SOC members who have joined in this particular program, Dr. Viren Nepalia Sahab, Dr. S.M. Mathur Sahab, who is the organizing secretary of the program, and all head of departments and participants who have joined this program, and hope that the deliberations, particularly that will be carried out on the intellectual property management, technology transfer, and commercialization, it will have a great benefit for the society, and also as well as for the scientists. Thank you very much. Thank you very much. Thank you, madam.
Sir. Thank you, sir. Now I call upon our Director Research, Dr. S.K. Sharma, sir, the convener of today's webinar, to please give a brief preamble and orient the dignitaries and the participants about today's webinar. Dr. Sharma, sir.
Thank you, madam. My greetings on the behalf of the MPUT and namaskar to all. It's really a great pleasure for me and even honor to be among us all on the occasion of this national webinar on the challenges of IPR for innovations in agriculture machinery. At the outset, I extend very hearty gratitude and welcome to our Honorable Vice Chancellor, Dr. Narendra Singh Ji Rathod sir, our own and Director, Central Institute of Agriculture Engineering and Project Coordinator of All India Coordinated Research Project on Farm Implements and Machinery, Dr. C.R. Mehta Sahab. Our eminent speakers, Sri Rajan Alavadi Sahab, IPR attorney from Gurugram, and eminent speaker of in this webinar, Dr. Yaswant Dev Pawar Sahab, who is heading the PFC cell of the TIFAC New Delhi. Respected Dean CTI Dr. P.K. Singh Ji, who is the convener of this program. Coordinator OSD to Honorable Vice Chancellor Dr. Virendra Ji Nepalia Sahab, Organizing Secretary and person who has given the new visibility to this patent activities in the university and the state, Dr. S.M. Mathur Sahab, Emeritus Professor, Scientist from ICR, and coordinators, Dr. Hemu Rathod, Head FRM, Dr. S.S. Meena, Dr. Manjeet Singh, and Mr. Naveen Kumar, and all respected members of Senior Officers Councils, all Dean Directors, faculty members, and dear students. The topic of today's webinar is really a tryst with destiny, I would like to say, for this university, because we are fortunate to have the Vice Chancellor of this university as a great visionary and personality, Dr. Narendra Singh Ji Rathod Sahab. Because if we see the trend of the innovations and technology development at the international, national, state, and the university level, this particular year 2020 is coinciding with a number of the progress and new developments. At the international level, under the Global Innovation Index, our country is ranked as increased from 52nd to its 48 at National Innovation Index. Now we are declaring, and there is a significant increase in the National Innovation Index since 2019 to last year. And in at the state level, our Rajasthan, though it is getting 30th rank into the National Innovation Index, but it is better than the last year. And very important, as told by our previous speaker, Dr. P.K. Singh Ji, our university in 2020 has excelled in many fronts and our ranking has improved a lot. And this has been of the particular focus of our Honorable Vice Chancellor on the innovations. He has always been emphasizing that our research output should be converted into the business output, and it means it will be converted into business output when there are innovations and there are new technological developments. So a number of issues have been there in the forefront in the university, and which are also at the national and international level. That whole ecosystem for the patent filing, new technological development should be vibrant, and there should be a kind of the business environment, more freedom and more facilitating environment for our faculty members. And in that way, many issues will be discussed in today's webinar, because topic is very important. And with that respect, some of the issues I would like to mention that what the university is already doing in this particular activity, but at the same time, we will be getting a number of views and expertise, that suggestions from our chief guest, our guest of honors, and all eminent experts. But I would like to mention that university in last 5 years, university filed more than 12 patents, and we have been granted 6 patents. Our sale for this patent improvement and facilitation package of practices, publication, and patent facilitation cell was established in the dynamic leadership of our Honorable Vice Chancellor, sir. and a number of webinars to create the awareness about the patent filing application, not only for the student and faculty, but progressive farmers were also involved, because we have been seeing that number of farmers from our southern Rajasthan and state of Rajasthan, they are developing small machinery and tools. One farmer recently came that I had developed a prom making machine. He has fabricated the machine, but he is not having that kind of the know-how, knowledge that how can it be patented. Then our patent facilitation cell is facilitating that farmer. In that sense, that a lot of new awareness is coming among the farmers and different stakeholders. Then a number of practical sessions were held by eminent experts earlier also on the patent filing application and how to take the legal issues related to the patent. And similarly, because in a university, for being the institute of the excellence, we need being counted through the how many number of patents are being filed by the university, how many research papers are being published into the highly rated NAS rated papers or the high impact factors. Then I would like to inform to the house that the H index of the university in the month of the July, 16th July 2021, it was 43, and earlier it was beyond the 52. So it is a kind of the total environment related to the innovation, science and technology have been developed in this particular area. And this has been because of the organization of such kind of the awareness programs, a focused training of the scientists, focused awareness program for the students, as well as better linkages with the ICR institutes, ICR facilitation center, as well as better linkage with the Department of Science and Technology, Patent Information Center, Technology, the TIFAC, New Delhi. And also, it is a matter of great pleasure for me to inform to the participants that our university has also declared impaneled a number of attorney generals for facilitating scientists. And recently, our Honorable Vice Chancellor has also allowed our scientists for paying the fee from the side of the university regarding the patent filing charges and other charges, because earlier there was no such kind of the conducive environment available, and this is the kind of the environment that has resulted into the filing of the number of patents that I told that it was around the 12. So there are but still as our Honorable Prime Minister sir told that India is in the phase of a crossroad regarding the protecting our new developments and technologies, because we have to focus, and our young scientists should focus more on the kind of the innovations than patent and then produce and prosper. That slogan for points he has given. And in the same fashion, our Honorable Vice Chancellor has also given that we should more focus on the number of research papers of the high rating, which is possible only when we take up the experiments on the which are very new and which are very innovative. At the same time, this is a kind of the academic environment, but at the same time, patent facilitation cell is one of the important requirements. Then education environment in the university, continuous motivation, then infrastructure for that part has been built up in the university, and same type of infrastructure also requires in the different SAUs and other organizations. Then business easiness, if a scientist comes with a kind of the interlinkages with the other private organizations as well as the farmers, then there should be the easy steps to coordinate and to facilitate the such kind of the innovations. And then overall environment, it is the need of the hour, and same points were focused by our Honorable Prime Minister when the technology vision of 2035 was declared in 2016 by the Department of Science and Technology. And in that respect, now there is a need that SAUs as well as ICR are focusing in this direction, and that is the reason that now MPUT is making the scientists and students more competitive with respect to the awareness that how patent can be filed, what are the processes of patent filing, what are the kind of the financial that ad that can be taken from the Department of Science and Technology, from the ICR itself, and with regard to the design and trademark, how it can be institutionalized in the itself in the process in the university, so that coming faculty, new generation, and the present faculty can take the advantage, and we can fail we can apply for more and more of the patents. I think all these issues regarding the more investment in the R&D in the university for better, highly competitive professionals and faculty for the patent filing in the university, then more focus on the number of patents per scientist in the university, in the ICR organizations, as well as more that kind of the internet subscribers from the university and more facilities in this regard. It will build up a good environment, and the will of our Honorable Vice Chancellor that more number of patents, more number of the copyrights, and more number of scientific research papers, and finally resulting into the bringing more our technologies into the business output will come. And I think all these issues will be taken well in the coming discussions by our chief guest, our guest of honor, special guest, as well as the eminent speakers. Definitely, it will give a way forward and a kind of the inspiration and great motivation to our scientists. And also at the same time, during discussion session, the questions asked by the scientists will be helpful them to solve their problems which they are facing in the issues related to the IPRs at their level. I once again extend very hearty welcome to our Honorable Vice Chancellor, Dr. Narendra Singh Rathore Sahab, Dr. C.R. Mehta Sahab, Sri Alawadi Sahab, and Mr. Yashwantji Dev Pawar Sahab, and all senior officers and participants across the country. Thank you very much.
Thank you, sir, for giving us a brief insight of the status of our university in the field of IPR. Thank you, sir. Our special guest of today's webinar is Dr. C.R. Mehta, the Director, CIAE and Project Coordinator, AICRP on FIM, Bhopal. He is with us, and I request you, sir, to please bless us with your wisdom in this field of IPR and farm machinery.
Thank you, madam. Good morning to everyone. Honorable Vice Chancellor of MPUT Udaipur, Dr. N.S. Rathore Sahab, Director of Research MPUT, Dr. S.K. Sharma Sahab, Dr. P.K. Singh Sahab, Dean, College of Engineering and Technology, MPUT Udaipur, Dr. S.M. Mathur Sahab, he was my teacher also. Both the keynote speakers, Dr. Rajan ji, Dr. Pawar ji, my teachers, my colleagues, my friends, and students participating from MPUT Udaipur as well as from different parts of the country. First of all, I thank university for inviting me for inaugural session of this national webinar on challenges of IPR for innovation in agriculture machinery. I also congratulate university for starting one new course, particularly in the area of AI and data science. And now university is organizing webinar on challenges of IPR. So both are the need of the hour. Both the areas need more attention, more knowledge, more practical application, because now things are changing very fast. So first, I will like to brief about the just trend in farm mechanization, because in this webinar we are talking about the IPR production, particularly in the area of agriculture machinery. So as you know that the sale of tractor is increasing over the years, and last year it has made a new record of around domestic sale of around 8 lakh tractors in our country. And this year also it is expected that tractor industry may reach a new peak of around 9 lakh, the trend which is showing right now. And if tractors are being sold, it is expected that more number of farm machinery will be sold. So to protect our researchers as well as industry, there is need for us to go for IPR protection in these areas. If we see the trend of farm mechanization in our country, over the years, it has increased and presently it has reached to 47%. And if we talk about the farm power availability in agriculture, right now it is around 3.5 kilowatt per hectare. And it is expected that during next 5 years, it should reach to around 4.5 kilowatt. Now I come to the title of this webinar, and that is on intellectual property. By its term, intellectual property, we can understand that it is talking about some property and that is related to intellectual of human being. So whatever we have some good idea or whatever we have some concept that can be copyrighted or that can be patented. So that is called intellectual property. Now the terms come that intellectual property rights. So if we go for protecting of our intellectual property, then if we have legal protection, then it is called intellectual property rights. And in this webinar, we will be discussing about what are the challenges, particularly for going for IPR in the area of innovation in agriculture machinery. Some of the positive aspects of IPR, because nowadays everyone is talking, even university has also filed number of patents, even ICR ICR is also focusing on filing of patents, copyrights, trademarks, even trade secrets, all are these properties. And why we talk about this? Because there are a number of positive aspects. One is that it helps in disseminating technical information to our stakeholders. And another, it avoids duplication of R&D work being done by different organizations, and it will justify the spending done in R&D because a lot of funds are being spent particularly for carrying out R&D in this area of agriculture mechanization also. And even we also know that there is duplication of work being done at different places. So if we go for IPR, it will avoid that. It also will give competitive advantage. Whenever we try to license any technology or equipment which we have developed to our industry, and if we have IPR on that, then industry will be keen to take, or industry will be ready to adopt that technology for mass scale production. Otherwise, they will be afraid that someone else may be IPR on that particular equipment or particular technology or particular software. So it will give competitive advantage to R&D organization as well as academic institutes also. It will also help in faster transfer of technology through licensing and other MOA, MOU, etc. to our stakeholders. And ultimately, it will help the farmers, who is our end users. In addition to that, if there are a number of companies you may be knowing right now that India is also not only focusing on Atmanirbhar Bharat, but it is also trying to have made in India technology, and in that it will provide the even export opportunity to a number of machinery which are being developed. And right now, I want to inform you that India is net trade surplus in the area of export import of farm machinery in our country. So these are some of the advantages. There are a number of other advantages, like it will also encourage innovation because it will motivate the person who had done research, because it will protect his IPR. And it will also reward the entrepreneurs, those who take the licensing of the IPR protected technologies. You may have heard about such IPR, particularly in the area of drugs. So when their drugs are under IPR, the companies have trade benefit Means they have pricing power also. Similar, if we have the IPR, particularly in the area of agriculture machinery, particularly for some important machinery or some important concepts, in that case, the companies will also have the trade advantage. There are a few disadvantages also for not securing IPR. One is because when invention, whatever invention we are doing, those are publicly disclosed and anyone can copy it easily. Another IPR disadvantage of IPR is cost of maintenance is also high. And sometimes it may happen that someone may take IPR on a particular technology which is need of the hour and who is not even commercializing that technology. In that case, the technology is blocked at that stage. So that is also one of the disadvantages of having IPR. But there are only a few cases, such cases. And if we talk about the IPR issues in farm machinery, there are some concern also. That's why we are slow in having IPR. Even at our institute also, we are filing number of applications for patent, copyrights, and even process patents also. Because it is easy to duplicate farm machinery. There are number of machinery. If anyone sees it, he can easily copy number of machinery because number of tools are simple to copy. Another, the cost of IPR is also high. Even in its maintenance cost is also high. And sometimes if we file for patenting, it takes long time also for the granting of patents. So that is also one limitation. And during that period, even technology changes also. So if we get, for example, for some machinery, a patent after 5 years of filing of patent, in that case, after 5 years, we may be using the another technology, or we may have come out with some better model with better innovation. So that will again require the filing of IPR for that another product, and whatever IPR we may have got, that may not have commercial value also at that stage. So these are some of the points, and during this today's webinar, all those points will be discussed in detail. I know only little bit because I have also undergone one training in 2007 or 8 when we have just started talking about IPR and its application, in particularly in the area of agriculture machinery. With these words, I again thank University for inviting me for inaugural session of this national webinar. Thank you, sir.
Thank you, sir, for your valuable words of blessings. And here I would like to quote, inventors are honorable not because they make a difference, but because they want to make a difference against all odds. And this is what you briefed us about IPR. I would like to quote John C. Maxwell here. He writes, the pessimist complains about the wind, the optimist expects it to change, and the leader adjusts the sails. So is our leader, Dr. Naren Singh Rathore, sir, our Honorable Vice Chancellor, who always adjusts the sails in times of adversity. Sir has continuously focused on IPR and its importance. It is because of his motivation and guidance that our university has recently got a number of patents to its credit. A leader is one who knows the way, goes the way, and shows the way. And yes, this definition goes well with our Honorable Vice Chancellor, sir. I now request our Honorable Chief Guest, Honorable Vice Chancellor, Dr. Naren Singh Rathore, sir, to give his inaugural address and bless us with his words of wisdom. Honorable Vice Chancellor, sir.
Thank you, Dr. Hemu. Good morning to one and all. I am really happy to see that our bold student and present director of CIA Bhopal is with us. I take this opportunity to welcome Dr. Mehta. And at the same time, I am also happy to see that Dr. Ranjan has also joined, and Dr. Pamar, I think he might have also joined. So this session which we are going to organize immediately after this inauguration will be more useful and more fruitful in real sense. So at the outset, I would like to welcome my all deans and directors, Dean of CTI, Dr. P.K. Singh ji, the former Dean, Dr. Rajesh Sharma, Director Research, Dr. S.K. Sharma, and Dr. B.K. Sharma, Dean of our College of Fishery, DRI, and special thanks to Dr. S.M. Mathur. Personally, I have seen that Dr. S.M. Mathur is always doing extensively in this particular activity. And I have seen when I was working around 8 years before, when I was working as a Dean of College of Technology and Engineering, I have seen that he was continuously being involved himself, and he has invited number of times many eminent speakers just to deliver on this talk. And every scientist is supposed to have something to contribute in this case. Dr. Minu Srivastava, she has also joined, Dr. Manjeet Singh, and all my colleagues from the different colleges. They are really be getting a more information in a subsequent session. As Dr. Mehta has also nicely described what is IPR. IPR basically, it is in fact is to encourage your new creation, new theory, new design, new development, new technology, new prototype, new artwork, even new invention, and which can ultimately be through this IPR, you may be in position to create your visibility, and it may helpful and a step forward for economic growth. That is a basically expectation, because what is happening, it is whenever anybody is coming forward to get a rights against his intellectual properties, then he might have already shown his innovativeness and creativity. Then only he is in position to convert a sort of a innovation in front of a general public. So that's why it will definitely increase the more opportunity, even job opportunities is there. And if we see in a totality, already Dr. Mehta has given that it will create and support high paying job on a particular innovation. This is my observation. Many people are doing when we are talking about startup, even a type of accelerator or any type of a new thing which is other than that of our regular operation. It may give that some intellectuality has already been introduced. A personal identity can be enhanced with the help of in case if he has got something, some worth to show that what type of a intellectuality he has shown is in particular job, and based on his own property, he will be having a right, and he may be having a legal right. Rather, a very good word was used, that intellectual property rights are legal right that provide a type of a protection for a original work, for a design or a development, even innovation and in invention. It may be of a scientific development or a prototype development, machinery as well, because today we are going to discuss. So it will definitely explore the possibility for scaling up and speeding up a particular a new skill for expansion. So basically what is happening, we will have to see that in a larger prospect, that a IPR, they may drive the economic growth and competitiveness in the present growing world. And as a result of this, everybody should have that type of eagerness to file a document, especially to get a IPR in his favor. Because what is happening when you are doing any sort of a innovation or a scientific activity, until unless you are having a right type of publication, but publication is being prohibited in order to file this. I remember when we have done a very good on a particular technology. It was in a solar dryer, more than 1,000 places. You won't believe, I am saying 1,000 places we have commissioned the solar tunnel dryer. But unfortunate part was that in continuation we have published a lot of good publication, and my publication, major publications, are from the very good high rating journal. And as a result of this, I was not in position to file a patent. But later on, I have come to know that somebody has already filed this patent. So basically, we will have to see that how we can protect ourselves against this type of a malpractice. It may be of a patent, it may be of a trademark, it may be of a copyright, and it may be of a trade secret. A patent may say, in case if you are it is used to prevent an invention which is being created by you, and even you will be solely responsible for selling it, and it cannot be used by another party without your permission. That is a basically patent. And as Dr. S.K. Sharma has also mentioned, our university has got a very good credit as far as the in a recent 2 year we have got a more than last year it was 4 patent in our credit, and this year 6 patents. So this is a really good thing our most of the scientists are doing, and as a result of this we are enhancing our market value as far as our educational system is concerned across the state or even across the whole country. Now people have realized that and this is the basic advantage of protecting of intellectual property. Whether it is a good publication or package of practice, or in case if you have already converted into the form of a patent, then with the help of this you will enhance your market value. It will create a new visibility in the market as far as your product is concerned, and simultaneously it will generate more income for your businesses through licensing or sale or commercialization. I would like to congratulate Dr. S.K. Sharma. We have given a licensing for a seed production to number of a private party last year, and it was our innovation, and we have developed a new seed variety not only in the maize but in other cereals as well. And as a result of this we have improved our market share to raise our profit as far as our revenue is concerned. I am happy to share that when I have joined this university, our revenue was hardly of 5.5 crore rupees per annum, and this year we have enhanced our revenue to the extent of 12.5 crore rupees. It is only because that we have created a right type of business. And it is true, when you are in the business of any R&D, you are supposed to extract the right business in terms of a money, in terms of some generation, because you have got a right to commercialize your on your patent, even your including buying and selling the patent, or granting or giving a licensing to any private or organization, just like what we have did in case of seed business. And here this is my observation: whenever you are filing a patent, it is really a way out. It is a nice way out, which will there are 3 words which are coming in my mind. First is let us give a concentration for a word so called invent. First is that you will have to invent. Invent means theoretically you just get some information in your mind. So individual critical thinking will be required at initial inception to derive some invent, and then collectively you kindly float this idea to your friends, colleagues, and head of the department, deans and director, or your managing director. And based on your invent, let us develop let us innovate something. Innovation means when you will innovate, you will develop a type of a prototype. Invent will be a theoretical perception, and later on when you will have some prototype, and if you want to make it commercialized, then you will have to invest. So these all 3 words, invent, innovate, and invest, these are the 3 steps for reaching to the stage of patent. So that's why I am always saying, and I'm really happy to share, even our civil engineering department, although this is not a so may say having a very good staff member, they have got a constraint of staff member, but they have done a really good work as far as the patent is concerned. Patent is not only limited up to utility or designing or plant. We will have to see in a totality that what thing you can give in a patent. As some of the drawback and some of the limitation has already been listed by Dr. Mehta. Same thing is true with the trademark as well. Trademark is another familiar type of intellectual property right protection, but here basically trademark will allow a consumer to easily identify particular goods and services. Let us see that a McDonald's, which has got its own trademark. Facebook has got its own logo. So likewise, everything has got its own trademark in the form of a symbol or sound or smell or color. There are number of things are available. Same thing is true with the copyright. At least our scientists should understand that we should not have any malpractices as far as the plagiarism is concerned, and that's why we made it mandatory that before submitting, even I have asked personally to my all MTech, MSc, and PhD student whether they are doing their PG work in agriculture discipline or community science or engineering and dairy and food other branches. I have personally met with them, and I have seen that what they are doing, whether a repetition is not is allowed. Basically, important thing is that we should not allow the things. It is a research which should have a newness. It is not that you are reinventing the wheel. So basically, copyright is also one of the things. I have seen many people are having a malpractice, and as a result of this, their paper, when they are submitting this paper to a number of a good publisher, it is being turned down. So we will have to see. Most of the scientists, a copyright owner has got exclusively right to sell, publish, and to reproduce any literature, even musical, dramatical, artistic people have got a number of things. One of my friend, he was saying that he has got a copyright on a particular song, and that type of a work created by an author, which will be preserved, that is a copyright. And same thing is true with the trade, the secret. I don't want to involve much more deeply in this case, secret of a business. I'm sure that our Mr. Ranjan will definitely throw more light, but I would like to mention, as far as the agriculture machinery is concerned, agriculture machinery are not only meant to increase production, productivity, or profitability ultimately, but they are also supposed to see that how we can reduce the cost of cultivation, how you can minimize the drudgery, especially if you see physically, if you are doing some sort of a on-farm application, you may be involved with a number of a drudgery. As far as the ergonomical studies is concerned, that basically farm machinery permits even efficiency improvement. And nowadays, when we are talking about a articulation of artificial intelligence in agricultural machinery, we will have to see that how safety, security, surveillance during your operation is to be supervised by a right means. And it is not a making a particular operation so simple, convenient, and efficient. You are supposed to see that how you can have a more production and productivity from a small piece of area. If we compare ourselves with China, China land holding is hardly 0.5 hectare land, whereas in our case it is around 0.8 to 0.9 hectare per person for marginal farmers as well. But even our productivity is not so good as, and if we compare ourselves with the Chinese, so they basically use of agriculture machinery, they lead to better utilization of input and improvement in a different agriculture operation, and particularly in large scale crop production. So we will have to see the importance of machinery. And in case of machinery, this is my observation. In the area of irrigation and post-harvest processing, number of a patent has been filed. But as far as the land preparation is concerned, at in initial inception, very less patent has been filed, especially on animal-drawn vehicles. And most of the things which we are doing in the area of irrigation, in a modern irrigation technique like sprinkler, drip irrigation, canopy under canopy, even post-harvest operation, even judging a maturity indices of fruits and vegetable, people have gone a number of and majority of patents belongs to the area of a plant growth and post-harvest operation. So here in a totality, we will have to see, let us chart out that what are the innovative things are required from say, land preparation till the material goes to up to the table of a users. So in this case, in between, there are a lot of unit operation is there. And this is also my observation, most of the out of you can say that 10 patent which is being filed, more than that of a 7 patent, they are being filed through a foreign companies. So we will have to see that how traditionally and how indigenous knowledge can be enhanced. And I remember in the field of pharmacy, earlier people were more interested to get all data manually, and then they are compiling, and then they have started digitalization. And then in between, there was a question to how to articulate the mechatronics in our agriculture machinery. And later on, nowadays, it is not automation which is a need of our, it is a artificial intelligence which is need of our for most of the things, whether in the area of irrigation, plant growth, or related machinery and post-harvest operation. In farm machinery, people are doing not only for digitalization, I can say, or automation. Now you will have to convert the things towards a artificial intelligence, and how we can have a different type of innovation in the machinery in a pre-harvest as well, and starting from a land preparation and even a sowing and each and everything we will have to see. And but many people are saying that whenever we are interested to find out challenges in the IPR, people used to find out that what are the, first of all, what is our strength. But basically, it is not always advantage we will have to see. In order to find out challenges, it is not that you will have to see what are the different possibilities. You will have to see what are the different disadvantages. Some of the disadvantages Dr. Mehta has also mentioned. that it can save a person time, money, and even heartbreak because of a number of things. Because even copyright, I would like to mention that copyright ownership does not own up. And here you will have to, even you will have to have a struggle, and you will have to fight again in the court when you will come across that already something was in favor of you as far as the copyrightable work was there, and you got that complete legal right. But even then, some people are doing mischief, and there are number of many court cases of individuals claiming copyright plagiarism that took years to be settled and resulted in a huge legal bill, and there are number of things are which ultimately we are loser. So I would like to mention that that the disadvantage, there are number of disadvantages of IPR. I'm sorry that there are few our colleagues, those who are responsible for propagating the IPR, especially our attorney is sitting here. I don't want to make any bad comment on this, but this is my observation. There are disadvantages of intellectual property rights, and they are not always apparent to individual looking to establish ownership and by security, copyright, or trade mill or patent protection for something they have created. And here again, as Dr. Mehta has also said, that it is not the, it will take time as far as the patent is concerned. Even it will cost money to file. And there is nothing is there. I remember I was struggling hard, but at this moment I am more liberal. Whenever any scientist is coming forward, I am always supporting him, and I am asking that in case if you want money from the university, we will be in position to give the money. But I got this setback long back when, and nobody has supported my case, and I was more interested to. So it costs money to file, even it costs money to maintain, it costs money to defend as well. After that, once somebody has already copied your patent and somebody has started a business based on your own creature, then what will happen? Only one option is available. You will have to fight in the legal court. When you go to the legal court, just because a patent assigned exclusively ownership right, it does not mean another person or entity is not going to use. They will definitely use it. But how? What are the permissible limit? Therefore, once you have got your own patent, but you will not save from the malpractices, which ultimately responsible for your overall losses in the system. So my request is that we will have to find out that what are the disadvantages. When I'm saying copyright ownership does not own up, and same thing is true with even a mark, trademark, which you are getting for expansion of your own industries or on your business. Somebody paying a lot of fees for getting a right type of a trademark, but even then, after at the end of the day, defending the mark, because prior to this. We will have to spend attorney fees is also there, registration and maintenance fees is also there, and once people will start copying your mark, then defending the mark will again a money consuming process. So we will have to see. And overall, I would like to mention in present context as well, this is my observation. I am having more than that of a 40 year of experience. I remember even in the 1986 when I was promoted on associate professor, it was a first when I came across in IIT Delhi. They have given a, they have invited Dr. Menon, who was a principal scientific advisor to the Prime Minister, Honorable Prime Minister at that time, and he has given a number of a good information that since we all were new bird in the field of a scientific community, so he asked us that how you can go for a good publication, how you can protect your publication being copied by other person. And that concept in 1986 or 87 perhaps it was there, but still at the end of a almost of a 30 year, we people are saying that as far as the IPR ecosystem is concerned, it is not so attractive, it is not so impressive, it has got a weak linkage still. And we will have to see that in ecosystem that what are the forward linkage, how we can file, and how we can have a right or a backward linkage in terms of a awareness. We will have to create a right type of awareness. And that's why I have congratulated Dr. Sailendra Mohan Mathur, because I have seen that from last 10 years, personally, I am seeing that he is always a spokesperson for this job. And recently he has published a complete guideline based on our university. It is a university publication, and very nicely when we have presented this publication in our board of of management, all honorable member of board of management, they have appreciated. But only thing is that as far as the challenges in IPR in agriculture machinery in India is concerned, as I mentioned, we have got a weak IPR net ecosystem is there. How we can create a right type of awareness? Even we will have to awaken the policymaker. I'm sorry to say, don't take it otherwise. A right type of a linkage is required. Even the government should come forward, and as far as the lack of financial support for filing, maintaining, and defending patent is there, we should give something extra to the such good scientist, and that we are supposed to keep in mind. And we will have to broaden our scope of work, because bulk of technology patent, as I mentioned, that are being filed by a foreign company, nearly 7 or 8 out of that 10 patent application which is being filed, it is through the foreign company only. We will have to encourage our own scientists. It is true, if Dr. Mehta will definitely endorse my statement. I remember when I was working as a DDG engineering, in a brief period, we have compiled a complete technology which a engineering division and which a division of fishery and other division people have published, and it was really a fantastic collection of more than 1,000 technology. You won't believe. But only problem is that our scientists were not encouraged to file such a useful document in the form of a patent. So there is a lack of government support, even a lack of a highest authority sitting on a chair that we were supposed to keep. This is my responsibility. In case, as far as the MPUT is concerned, some scientists has done some good work. It is my responsibility. It is the responsibility director research as well. Individual deans are responsible for this. They should identify this type of a new creature, and we should file. And whatever financial support is required, even nowadays I have seen there is a lack of interest in R&D activity as far as the design technology for modification, alteration, and perfection is concerned. Even it is our job of a Krishi Vigyan Kendra. Krishi Vigyan Kendra are essentially confined, and they should revolve on a single word that is called as a TADA CB, TADA-CB. That TADA CB means a technology assessment, demonstration, perfection, modification, and perfection, and then capacity building and training. So that is a expectation out of a Krishi Vigyan Kendra as well. So in case if something is already available in the form of a commercial avenues, our extension scientists, they are supposed to will assess this technology, and for that we are supposed to attract them towards this new technology, how they can assess as far as their perfection, as far as their articulation in our local area is concerned. So we will have to generate a right type of interest. If you remember, Dr. R.S. Paroda, he has introduced, instead of Arya, he mentioned that before Arya, it should be Maya. Arya means it is attracting and retaining youth in agriculture, but Maya is a motivating and attracting a youth in agriculture. So before attracting, you are supposed to motivate this. So if we are asking that we are supposed to have a very good setup as far as the patenting is concerned, and university should get a credit of a number of a patent, we should have a we should motivate our scientists, and they should have a right interest in R&D, even design technology for modification, alteration, and perfection. And we will have to keep a right transparency. It is not like that only agriculture will get, or only fishery will get. In case even dairy college, if 2 or 3 scientists are there, those who are responsible for research work, we should give equal importance to them. Transparency and creating awareness for each and everything, starting from registration process, and finally to provide technical backup support for overall its operation. It is a responsibility, and I would like to urge to Director Research that kindly see that how we can create you have got a very eminent scientist, Dr. S.M. Mathur as well, and kindly do some work. And let us keep a in-house meeting and ask all our scientists. They should present that what they have done as far as the new innovation is concerned in last 5 years or 7 years. And as you are already compiling a lot of information and on a technology developed by MPUT that is in final shape, and out of this technology which you have already compiled, kindly find out few more scientists, and accordingly let us give them support to the scientists to file a patent application, whether online or offline, and which is in present is not so attractive. That's why I have mentioned it, and we will have to see. At last I would like to mention, whatever maybe the IPR issue is there, plagiarism is a major issue. How to prevent it? And for that, a person should have its own integrity, and he should have a own honesty. And it is the act of stealing or theft of another person intellectual property, which comprises of idea or even discovery, in invention, and original work of authorship, even their word, slogan, even design, and number of information which we are passing through. People are taking this information. I don't want to say on, I have seen number of times what our scientists are doing. Our scientists used to float a new idea, but unfortunately these our scientists are not going up to the last point in a final propagation of that technology. And meanwhile, some other people, I remember our molecular biology people, few scientists, they have done a very good work, but whole credit went to some other scientists working in other university. So basically my appeal is that all scientists, if you have started a new innovation, if you are trying to articulating your creativity in designing a new idea or a new technology or new system or any new prototype, kindly go extensively till it will reach to the far in a right shape. You will have to see its overall, that how you will pass through this technology to a end user, and what are the different means available in order to make its proper visibility, and having a right type of a understanding amongst all people, that you are supposed to keep in mind. So my request to my all scientists is that you kindly keep in mind that intellectual property rights, all issues are being especially and exclusively designed to protect your own thinking, to protect your own innovation, to protect your own creativity. Only thing is that you are supposed to put your each A to Z, each and everything you are supposed to put, then only you will get a right type of reward out of this. I am really happy to see that Dr. S.M. Mathur has initiated this particular program, and Dr. C.R. Mehta has spared his valuable time, and all my deans and director, deans of CTA and director research and dean of CCS, and everybody deserve appreciation. With this word, thank you very much. Thanks a lot to all of you. And I take this opportunity to welcome all my eminent speaker as well. In subsequent session, I will not be in position to join you, but I have gone through with their candidatures, and all you have really invited a very good speakers, and I'm sure our scientists will get a major benefit out of this whole deliberation. Thank you very much. Thanks a lot to all of you.
Thank you very much, sir. We feel highly blessed with your presence. You have always been instrumental in reformative and transformational issues of the university. Thank you very much, sir. Definition of guideline is a general rule, principle, or piece of advice. Its recommendations, instructions, directions, suggestions, advice, regulations, rule, requirement, specifications, percept, and principle. Our participants must be thinking as to what are the guidelines for patenting, copyright, trademark, etc. So for this, we are thankful to the organizing secretary of today's webinar, Dr. S.M. Mathur and his team, because the guidelines are ready. I now request our organizing secretary, Dr. S.M. Mathur, Emeritus Scientist, ICR, PI, Acripon FIM, and convener of OPFC, to please brief the participants and the dignitaries about the guidelines to be released today. Dr. S.M. Mathur, sir, please.
Thank you, madam. Honorable Vice Chancellor, Dr. Narendra Singh Ji Rathod Sahab, Director, CIE Bhopal, Dr. C.R. Mehta Sahab, also Coordinator of the Acripon FIM, Dean CTA, Dr. P.K. Singh Ji Sahab, Director Research and the convener of this program, Dr. S.K. Sharma Sahab, Deans, Directors, SOC members, my dear colleagues. The guidelines which are going to be released by our Vice Chancellor was his guidelines he has created a patent and publication cell in the university to take the various technologies and the processes developed in the university to the market. And under his chairmanship, a committee was formed and the responsibility was given to me. I felt that there is a need of a clear-cut guidelines for the university to file a patent application or a copyright application or geographical indicator, whatever IPR it may be, and how to make it commercialize. And we have developed these guidelines, which consisted of 30 chapters and having the information right from beginning to end. That means how a person can file a patent, what are the things to be patented, what are the things to be copyrighted, and from where he can get the funds for filing this application, and how he will commercialize and what benefit sharing he will get. So after studying the guidelines of ICAR, which was revised in 2018, and the guidelines issued by the government of Rajasthan, Department of Science and Technology for various colleges and the university in 2020, we have developed the guidelines for intellectual property management, technology transfer and commercialization. These guidelines were approved recently in the 55th Board of Management of the university, and I hope with the help of these guidelines, the scientists and the researchers of the MPUAT will be benefited, and they need not to walk here and there that how to file a patent application. All kind of forms, process, what are the things required to file a patent application, what are the things to be kept in mind while filing a patent application, all information is there. The book consisted of 80 pages, including the various annexures which is required to be filed with the patent application. So I hope these guidelines will be very beneficial for the MPUAT scientists and the researchers. And these guidelines are only applicable for the MPUAT scientists and MPUAT researchers. So I request our Honorable Vice Chancellors to please release these guidelines for the MPUAT scientists and researchers. Thank you, sir.
Congratulations to all.
Congratulations, Dr. S.N. Mathur and Director Research and all deans and director. Thank you. Please keep it up.
Thank you, sir. Thank you very much, sir.
So I think we start our technical session. So our the first speaker is Mr. Rajan. He is from Gurugram, and looking to the need of the topic, as topic is dedicated to IPR in the field of agriculture machinery. So I have selected one of the speaker as Mr. Rajan, who is MTech in Farm Machinery and Power Engineering from Pantnagar Agriculture University and doing practice in IPR, having his own firm in Gurgaon, and also on and off assisting us for filing our patent applications. He has also filed number of patent applications of our university, and as he has the man of IPR as well as a strong background of farm machinery and power engineering, therefore we invited him to deliver a talk on what are the various challenges in filing a patent application, particularly in the field of agriculture machinery. As far as I know, most of the agriculture machineries, whether it is operated on farm or off the farm, has the same components. Say, for example, we take the example of a machinery working in the soil. Definitely, it must be having a shovel. So, shovel is a very broad term, and when we file a patent application, we are more specific about our inventions. So, filing a patent application for a machinery is a different from filing a patent application particularly for the agriculture machinery, because it is required to be formulate the claims in a very special manner. To prepare a write-up is also in a very special manner. So I will not take much of the time. I invite Mr. Rajan to take the session and deliver his talk. Over to Mr. Rajan, please.
Thank you, Dr. Mathur. It's always a pleasure to interact with you. Good morning, everyone. And thank you to the Honorable Vice Chancellor, Dr. Rathore, Director CAA, Dr. Mehta, Dr. S.K. Sharma, Director Research MPUAT. In fact, I had my first experience of delivering a talk at MPUAT way back in 2015, when Dr. Mathur had organized a session, and that time it was a physical session, September 2015. And I remember at that time there was a talk of establishing the IPR cell for MPUAT. Happy that it is now in full-fledged mode and operational. And like you said, sir, yes, I come from an agriculture engineering background, and I did my master's in farm machinery, but it was from PAU Ludhiana. So sorry for that.
Sorry,
That's
sorry.
okay. And yes, I've also been part of ECRIP, and I had the privilege of attending 2 coordination committee meetings way back 2 decades back in 2001 and 2 at Coimbatore and Akola. So I have gone through all the phases, and I've also been a member of Indian Society of Agriculture Engineers. So without taking a lot of time, I'll try and share my screen. Is it visible?
Yeah.
I think that's better. Well, yes, there are unique challenges for filing or protecting your intellectual property, particularly with respect to agriculture and farm machine. In fact, if we look at agriculture engineering, there are challenges in every stream, but particularly with agriculture engineering, the challenges are unique. Why? Because we learn every stream has an application in agriculture engineering. We could have invention related to AI, which is useful in agriculture machines. We could have an invention related to biotechnology engineering, which is again for agriculture engineering, and a mechanical invention which has an application in agriculture machine. So agriculture engineering is, in fact, I could say that it's a consortium of engineering subjects. So we have our own unique challenges, and at the same time, we also have our own advantages. Well, everyone has already talked about what is intellectual property. I would just briefly touch it. We can classify it in patents and designs, the innovation part, copyrights for the literary part, trademarks for brands, and trade secrets for something which we are not ready to disclose. Product of mind, it's a product of research. And as with all forms of property, it has value and deserves to be protected. I think we also need to understand that the IP deserves to be respected also, not only protected. We need to respect others' IP rights, and at the same time, or only after that, we can expect others to respect our IP territory. Since we are talking here to more of the faculty and the research scientists, I would try and limit my talk to patents, briefly touch upon designs and copyrights. Okay. Now, one of the myths that we have in patent is that to have a patent, you need to have something very complicated or a sophisticated invention. Rather, it is something, any invention which is useful, has a technical advancement, and which could even be a simpler one. Like if we take off the inventions like safety pins or the barcodes, today when we see in retrospect, they seem to be some kind of a useless inventions. But at the time when these were invented, they were a high value inventions. And in fact, they have a utility even today. The patents might have lapsed, but the utility still remains. Now, just for academic purpose, we have 4 patent offices in India. In fact, there are 4 branch offices have been set up just to ease the filing. That was pre-emails and pre the online modules, everything. And the jurisdiction of an applicant is decided based upon his address. So for all the applications from Rajasthan or MP to Udaipur, applications are filed with Delhi Patent Office, or the jurisdiction is Delhi. But as we stand today, the present scenario is that the examination is centralized. So it is not that your examination or your application is examined only by the office where you filed it, because the patent office is a completely paperless office today. Just to give you a brief trend of the patent filings in India. These are the latest figure as per the published annual report of the Patent Office. Because last, I think it's 2018-19 publication. You would see that the number of filings were around 50,000 or just over 50,000. Now, if we look at the number of applications filed subject-wise, you see that in 2018-19, only 411 applications were filed, which were categorized as applications related to agriculture engineering. Now, within these 411, how many, most of them are actually related to the post-harvest technologies, PhDs, and soil water engineering, very less to farm machinery as such. So here we see like the contribution, it's negligible. At the same time, we could also see it to our advantage that the scope that we have. Now, if we see the state-wise applications filed in 2018-19, the total number of applications filed from the entire state of Rajasthan were 305. Now, these are the applications, patent applications in all categories of innovation or all subject matter. Some of the scientific research and development organization, we do see that ICR is listed as on the 5th number as one of the top 10 institute of the scientific research and development organization. But within the ICR, how many applications are actually being filed from agriculture engineering or from the ACRIP sessions? Now, I just pen down some thoughts like what could be the role of ACRIP on farm, the project that Dr. Mehta has been handling on farm machinery, ACRIP on agriculture engineering as such, and the Indian Society of Agriculture Engineering. Sorry to say, I might be crossing my boundaries here, but we, as far as I have attended the sessions of ISAs, there has never been a session on IPR ever on in the Indian Society of Agriculture Engineering, the 3 days of workshops. There was one session that, a brief session that I conducted, that was in 2017 in Hisar, when the ISA was held there. Similarly, the workshops, the coordination committee meetings, when we are talking about the awareness to a scientist, I think the best platform is already with you. The ACRIP coordination committee meetings, the ACRIP workshops. If a session is organized over there, a very brief session, I'm not saying a full day workshop, maybe just an hour or an hour and a half, at least it would, with practical examples, that will help the engineers and the scientists to better understand the nuances of patents or the intellectual property. Now, what exactly can be patented? We can have a chemical substance, a process, a product, device, or a system. One of the biggest challenge that our scientists face or the SMEs face, and these are the questions I'm talking of on a practical aspect, which I've encountered number of times in the last 10 years or so, is identification of your invention, which is very important. Well, like Dr. Mathur was given an example of tillage machinery, having a shovel or a cultivator, having some spring tines or other forms of tine. Now, if I try to draft my patent application on a broader frame, claiming the cultivator as such. I have not developed the cultivator. My invention was a very small part of it, maybe a spring-loaded time. So I need to carefully draft that my application is drafted only to the time. Cultivator is an application or a machinery which is using my time. So identification of your invention is, or your inventive part, inventive concept is very, very important. And we also need to understand that not everything that we develop can go in for patent. We might have a patent for some. We might file a design application or an industrial design, like it is called, for some other development, or for something else, like it's a research paper or a review paper or a concept that we have developed. We might have a copyright on the literary part of it. So segregating all these at the basic level, when the scientist comes to you to discuss his technology or discuss his probability or intent to file an IPR, that is important. As for the Patent Act, what you can patent is a machine, manufacture, process, or composition of a matter can be patented if it demonstrates the following three characteristics: novelty, inventiveness, and industrial. Now, coming back again to an example of cultivator with a spring-loaded tine. Now, my novelty resides in that tine, not in the cultivator as such. You could say that cultivator with the tine, but again, that would be just an application. My inventiveness resides in the development of that tine or some kind of a particular type of a spring or some shape that or a curvature that I'm giving to the tine for the operations. Like we all know, we can have a patent on the product or the process. I'll come down to some of the exclusions of patentability later. But when we talk of process, we cannot have a patent on the process of farming or a process of agriculture or a horticulture. But we can have a patent on the machines that we are developing. So again, I come back to the same thing, identification of your invention or the inventive part of it. It is very crucial, and properly drafting it. Process defined as a means to end, a means of doing something new or a new way of doing something old. Now, I can give you and non-obviousness, though this example is not related to agriculture engineering, we can have an example of the spring-loaded tines in the cultivator over here. Now, there could be a cultivator which had rigid tines and a cultivator with a particular or a specific curvature with spring-loaded, and it's a spring-loaded tine. So my inventiveness lies over there, and that is non-obvious. Just to summarize, it should include an inventive step. It should be new and should not be excluded by the statute. The Patent Act provides certain exclusions or certain types of inventions or technologies categorized, which as per the Act are not to be patented, or a patent is not to be given onto those technologies or inventions. A patent has a lifetime of around 20 years. Yes, obtaining a patent can take many years, and 5 years back, it used to take way many years. But with the introduction of expedited examination systems, with hiring of more examiners, speeding up the examination process, today, depending upon the technology, it is possible to get a patent in just an year's time from the date of filing, provided all the formal obligations or compliances are complied with. Now, another aspect is why we say patent takes a long time. If you try and look back, if you would have filed some applications 6 years back, but at that time you did not file the request for examination, which is mandatory, and you or your attorney filed the request for examination 4 years later. So you cannot say that your patent is pending for the last 6 years, but your examination is pending only for the last 2 years. Your patent applications would only be taken up for examination if you would have filed a request for examination. Now, who can apply? Of course, the inventor of the invention, he has the first and foremost right to file it. There are assignees, like if an inventor is an employee of the university would be the assignee. Or in combination, both of them can file. A flowchart, but to explain it on a very simple term, file an application, either a provisional or a complete. A couple of things come up here and have been said by Dr. Mehta and the Honorable Vice Chancellor also. That when you filed a patent application, or when you are working on the application or any concept, what we in India try and do is we would go to the attorney or to our IPR cell only when our invention is complete, the research is complete, or the prototype is complete, and the machine is ready to be launched. Then we will start the process. Rather, the process should have been started when you had some certainty about the invention. At least you should have filed a provisional application, so that by the time you've completed your research and now you're ready to file the complete, you have your prior rights a year back dated a year back. Once your application is filed, it will get published. If you are not willing to have an expedited publication on it, by law, it would be published after 18 months. But meanwhile, you can always file your request for examination. Some people, some scientists wait for the application to be published and then they will file the request for examination. The Act does not stop you from filing the request for examination at the time of filing your application itself. You don't have to wait till the date of publication. Now, once you have filed an request for examination, depending upon the technology, biotech, chemistry, mechanical, electronics. In fact, for the biotechnology and chemistry cases, there is hardly any backlog at the patent office now. even without filing an expedited examination, your application would get examined in around 6 months to a year. But for mechanical engineering, agriculture engineering, of course, on farm machinery, which would be examined by the mechanical engineering department, and electrical electronics, there is still a backlog. Once you receive your examination report, you need to file a response to it. Once the response is filed, if it is found to be satisfactory, a patent would be granted. Or if the controller or the examiner has further objections on it, or are of the opinion that the objections raised in the examination report have still not been complied with or fully met, they would either issue a second examination report, so a subsequent examination report, or they would appoint a oral hearing. And then the matter would be either refused or granted. Now, between the publication and the grant stage, there is a pre-grant publication. Any third person who comes to know of your invention and seems that this patent should not be granted can file a pre-grant opposition. Pre-grant opposition period extends from date of publication till the date of grant. After the patent is granted, India has a post-grant provision of post-grant opposition also, which would run till 1 year after the grant of patent. So till 1 year after the grant, an interested third party can file a post-grant opposition. We'll not delve into these modules or these nuances in detail. Now, what are the aspects considered at examination? Novelty and inventiveness, patentability, and other formal and technical objections. Like I said, the Act provides for certain exclusions to patentability, which are listed in Section 3A to 3P and Section 4 relating to atomic energy, which of course would not come into play for MPUAT. These are the non-patentable inventions, invention which is frivolous, which is the invention, the primary or intended use or commercial of which would be contrary to public health, public order or morality, mere discovery of scientific principle. Well, on a practical note, the objections that we encounter on our patent application, say if it is a application for agrochemical, there could be an objection, or there would be an objection on Section 3D, which precludes from patentability a mere discovery of a new form of a known substance which does not result in enhancement of known efficacy of that substance. So if you have formulated some agrochemical, the compound is already known, there could be an objection on Section 3. So you will have to defend it, why it is not a mere new use of the existing compound. Or there could be an objection under Section 3E, which precludes from patentability a substance obtained by a mere admixture resulting only in the aggregation of properties. Or coming down to farm machinery, we could have an objection under Section 3F, which says the mere arrangement or rearrangement or duplication of known devices. Now, if I come back again to the example of the cultivator with the time, Now, cultivator is known, tines are known. If it's a spring-loaded tine, the spring as such as a component is known. Now, the spring is known, tine is known, the frame of the cultivator is known. So in all probability, there could be an objection that what we are trying to claim is just a workshop modification. It's not an invention. Over there, we need to defend it, how the invention or how this spring-loaded tine is unique. That is why it is very important to properly draft the application. Because the cultivator would be known. If I claim a cultivator, then I should restrict my claims only to the tine. Like a method of agriculture or a horticulture is precluded from patentability, but at the same time, an equipment for this method, we can claim a patent for that. I can give you one example on this, which a case which I particularly handled almost 15 years back, that was related to a seed tape, which again, it was from a foreign company, not an Indian company. Now, inventors or the applicant were trying to take a patent on a biodegradable seed tape for precision sowing. One of the objection was that it is a method of agriculture, because obviously the operation of sowing is a part of agriculture. There we defended that what we are trying to claim is not the operation of sowing. What we are claiming is the seed tape as such, which is biodegradable. Yes, the seed tape helps in precision sowing. Then section 3I, any process for medicinal, surgical, curative, prophylactic, or other treatment of human beings, or any process for similar treatment of animal. This might not be related to agriculture or the agriculture engineering part, but yes, it could be related to the veterinary people. When we talk of AI, one of the objections that we encounter for computer related invention is under section 3K, that the invention is a mere mathematical or a business method or a computer program per se or an algorithm. So when we talk of AI assisted or sensor based farm machines, again, we need to be very careful as to what part of the algorithm we are putting it in, or the AI we are trying to put across in the patent invention as such. Because our main invention is that machine. Yes, it is being assisted by AI or sensors and motors. Another exclusion is listed under 3L, a literary, dramatic, musical, or artistic work for which we have copyright. A mere scheme or rule or method of performing act, a presentation of information, all these type of inventions, they are not patentable. An invention which in effect is a traditional knowledge, again, we might be using our traditional knowledge in agriculture practices, but we cannot stake a claim on patent on. We cannot have a patent on a traditional knowledge. And a patent cannot be granted in respect of an invention relating to atomic energy. Well, I don't think this would be relevant to any of the inventions that would come from MPUAT, unless and until we are working on some radioactive material. like I said, a response is required to be filed to the examination report, and as per the current patent rules, the response is required to be filed within a period of 6 months from the date of examination report, and which can be further extended by a maximum of 3 months. So you cannot delay beyond this. Once you have missed this deadline, your application will be abandoned for non-filing of response. Now, once your application is abandoned, you cannot refile it. Well, you can refile it, no one will stop you. But when it would be examined, your own invention, even if it was novel or inventive at that time, would act as a prior publication to your examination, to your present application. So it is very important to take care of the deadlines and patents. Type of claims, some of the claims that we come across, and for the chemical or farm machinery. Composition claim defined should be defined by definite ratio percentage. We cannot just say that we are claiming a composition of A, B, and C. We could have done that if A, B, and C are novel. But if A, B, and C are already known and we have devised a particular, or we have researched on a particular ratio of percentage of each of these components, which has resulted in a synergistic composition or substance D, which is unique because of these ratio percentages. So you need to identify the specific ratio percent. Process or method claims defined by definite process steps and parameters. Method should have a technical advantage and should not be a mere operation of a claim system. I cannot file a claim or cannot get a claim onto a method of operating the cultivator. If it's an article, it has to be defined by definite constructional features or interrelationship between different parts. Computer-related inventions allowable only in technical conjunction with the hardware features. The advantages we all know, and this has been recited since morning a number of times. It gives the inventor or researcher the right to prevent others from copying, manufacturing, selling, or importing the invention. But again, not a mere filing will give you those rights. You will get those rights only after you get your patent, or your patent is registered, or patent is granted. You cannot file a case against anyone till your own patent is granted. Maximum protection of 20 years. After 20 years, patented invention would come into public domain. And even for these 20 years, you have to file annual maintenance or renewal fee for your patent. It's a good platform, good tool to build your business. We see very less scientists or students from our universities, particularly agriculture universities, who actually work on an invention or an innovative problem and then use that technology to launch their business. In fact, I know of one such student from MPUAT, and we have helped him file his patent application. I'm sure most of the faculty would be knowing Mr. Narayan Gujjar. He worked on some kind of nutrients, water retention nutrients, and we've already filed the Indian application for him. We have also filed the PCD application, and now we are in the process of filing applications for other countries. And he has, I think, launched his company on that technology. So patent can be licensed by the inventor to make it available for others to use it. If you don't want to commercialize it, you can license to someone else. Some of the practical tips: keep invention confidential prior to filing a patent. Publication, howsoever good or small it may be, it will bar your chances or hamper your chances of getting a patent. Because one thing that we have learned in research, I know it since I come from a research background, is publish a paper. When we are fine, you can start publishing your paper or start writing a paper, but at the same time, talk to your IPR cell, talk to your patent attorney to file your provisional application at least before your publication is done. Don't over discuss your invention in any of the workshops. If it's something new and very close to your heart, try and formulate, work on your own, and or in a closed network with your IPR cell or the scientist helping you, but don't disclose it openly on a public platform. Well, coming down to the designs, I've shown a very futuristic design, but believe me, you don't need to have a futuristic design or such kind of design elements to file for a design application or get a design. You can even go in for your own agriculture machines, or say you've done some changes to your seed metering mechanism, the fluted rollers or the discs. The technology remains the same. You have just changed the shape. File a design application. We've done a number of design applications for MPUAT, and we regularly file it for other agriculture universities and farm machinery manufacturers. It could be very simple, like a shoe design. Now, if I come down to the design, state-wise design applications also, now you see where we lack. We, from state of Rajasthan, we had just 76 design applications from the entire state in 2016-17. Well, in 18-19, the figures might have increased, maybe in 3 digits, but still not a very considerable number. One aspect that we need to understand over here is where we can file a design and where we can file a patent. Patent will protect your technology or the functionality of your invention, be it a process or a product. The design would only protect as you see the object. So the aesthetic appeal of it. If you can see a design, a different shape of an object, having a same functionality, you can file a design. But your design will not protect the functionality of the invention in it. A design covers the outward appearance of an article or a product, which plays a very important role in the distinctiveness and the value of said articles or product for an organization. That is why I said in the very beginning, we need to understand for what inventions we need to file a patent and for what inventions we need to file a design. Could be a surface pattern, color or a line or combinations. No protection to the structural or utilitarian features of the article. The shape of a bottle, shoe, some more design elements. Other examples could be hair dryer, car, tail lights, or an agriculture machines, the gear systems, the fluted rollers. Even we filed patent design applications for planters, your pots. We have one client who regularly comes up with a new designs for their planters. Prerequisites, it should be novel and original, applicable. You can produce that design on an article or should be visible on the finished article. And even in design, there should be no prior publication or disclosure. So between patents and design, one thing similar is there should be no prior publication or disclosure in public domain before you file your application. The term is only 10 years. Once granted, you have a right for 10 years. You don't have to pay annual maintenance fee. Close to 10 years, if you feel you want to extend it, you can file a request for extension of a renewal of a design, and your protection will be extended for another 5 years, not beyond that. Increases the commercial value of a product. Who doesn't want to buy a product which is a new design? We always try and look for new design and at the same price. So the design element of a product gives us that advantage in a competitive market. It safeguards the aesthetic values, and registration and protection of design definitely helps to boost creativity of industry. Now, it is not that if we have filed an application for a patent, we cannot file an application for a design, or if we file an application for a design, we cannot file a patent application or a trademark application. A product can have all the IPs assigned to it. In fact, for a commercial value, a product would always have. IP is an ecosystem. We cannot say that we just need patents, or a design. If I have a new design for a machine, I'm selling that machine under a brand name. I should have a trademark for that brand name also. I develop a manual for that machine. I should seek copyright protection for that manual. There is a color combination, or there is an artistic work which I've done on a machine. Why should not I protect that artistic work under the copyright regime? It's just a flow chart. The process is very similar to patent, only that we do not have a pre-grant or a post-grant oppositions in this. The timeline is very short. As per the Act, the design application is ordinarily granted within 6 months of filing. With a speedier examination system, we get the examination report within 1 month, and you do not have to file a separate request for examination. Your application for design is kind of a request for examination also. Once examination report is issued, you file the response within the due time, and your application gets registered if there are no substantial objections. Once registered, then any competitor, or you, if someone else has copied your design, you can file a application or a request for cancellation of that design. as an organization, what could be the goals for a company developing an IP portfolio? Similarly, for a university to increase its ranking and the overall culture, you need to have an IP portfolio. I say IP because it would be patents, trademarks, sometimes, or copyright and design. A proactive approach towards protecting its IP, which I'm sure MPUT is now taking. A watch on competitors or licensees, patent filings. Well, this may not be of much of practical use for you for patents, but at least you can keep a watch on the copyright. And identification of a problem, patents in an early process, and having a dedicated IPR cell, which the university now has. One thing that I've missed over here is copyright. I'll briefly touch upon that. Like I said, if you cannot file a patent, you cannot file a design. There would be certain departments in the university which do research, but their research is not kind of an industrial, or there's a new process. Say, Department of Business Management, they have come up with some new concept of say assembly line or a manufacturing process, in a manufacturing process, which is a concept can be used in a flow shop. There cannot be a patent onto it, there cannot be a trademark, there cannot be a design onto it, but we can always file a copyright application for that concept as a literary work. Or say Department of Social Sciences, they have done some research. We can file a copyright, they can file a copyright application. So as a overall, for the university, it would always be a comprehensive IP portfolio. For farm machines, yes, patents and designs are more relevant, but for other departments, copyright could be more more relevant. Well, that's all from me. I understand there's a question hour session and we'll take the questions later, but if anyone wants to ask any question now, if the convener agrees, I'm ready to take the question. Over to you, Dr. Madhav.
Some brief questions we can take here.
As you say.
Because the continuity will break till the question hour.
Sure.
So if there is some question from some of the participants, we can take here some questions also. Yeah, if anyone has any question.
The participants, please, if you have any questions, raise your hands raise your hands virtually. You can right click on the participant, your name, and then raise your hands. Yes, sir, we have one question. Question session, sir, who's taking?
Yeah, you can, or participants can do, you can just jot down your question.
Sir, there's one question from Professor Suman Singh. Can we file a patent oblique design on modification of any pre-invented technology?
Well, yes, we can file. Obviously, when I come back to the example of the cultivator. Now, cultivator is a pre-invented technology. What I am doing is I have developed a spring-loaded time for that cultivator. So you would always have your research over some existing research. But the grant and refusal of that particular patent or a trademark would depend upon how substantial, innovative that modification is.
So any other question, please?
So right now there's no question. There is one question, that is only Suman Madam's question, sir. And one participant had given a question. If any technology invented by somebody else, that is Suman Madam's question. And one said it can be published before filing patent. So that
like I said, no, you should not.
Yes. So till now we've got only two questions.
So thank you very much, Mr. Rajan, for delivering a very nice session with say some very good examples. Sir, I have a question.
Yes, sir.
Which I faced a lot while filing the patent applications of our innovators. In most of the cases, you can say directly mechanical engineering cases, we have direct claims. But here we have some primary claims, secondary claims. So can you elaborate something about this primary and secondary claims?
Okay. Well, this is again a very detailed discussion, but I'll keep it short. Claim is, I'm sorry to again go back to the cultivator example because that is the easiest one. I've been taking it over. So don't say that I have some kind of inclination towards cultivator. No. But now you've developed that the spring-loaded tine. Your primary claim would be a spring-loaded tine or a spring-loaded tine comprising, say, the spring element. If there is certain kind of another component that you have added, or you have changed the curvature of the tine, and which is an essential element. So this would all go into the primary claim. Your secondary claims could be a spring-loaded tine as claimed in claim 1, wherein the spring has a stiffness or a resistance of this much amount, or wherein the tine while in cultivation has a play of this much, or say in the principal claim you have taken a curvature within a range. Now in the subsequent claim you could narrow down that range. So we can always during the question hour or next time we can have some live cases which I can share with you that would give you a better understanding of that.
So there's one more question from Rajan Sharma ji. His question is, a research at our institute has identified a new protein in urine of dairy animal, which can be used for a particular physiological condition of dairy animal. This protein can be detected by already known method. Can patent be obtained being a novel protein?
Well, I think if he reads this question, his statement is very good, and he has answered it. It says novel protein. So we need to restrict our application to the novel protein element because he's saying the method is already known. Then why do I have to dilute my application by claiming the method?
130, after 130.
And this protein is used for some particular physiological conditions. Why do I have to involve the animals onto it? I would like to keep it broad, application to broad, only to the protein. So yes, we can.
Thank you, sir.
Thank you.
So thank you very much, Mr. Rajan. Here I want to mention that MPUAT is very much associated with Mr. Rajan from a long time, right from 2015, and he has filed a number of patents from MPUAT, design patent also, and recently we got a design patent through him also, and we got a 2 or 3 patents through him also. And the biggest advantage of filing the patent application with Mr. Rajan is that he is from agriculture engineering background, and it is also very easy for us to explain that things to him instead of explaining the things to other attorney. So we are very, very thankful to you for providing us the facility of filing the patent applications through you at a very, very, I can say, as per the structure of the university, at a very, very nominal charges, I can say, which is nothing as the case is nowadays. So, sir, thank you very much, and
Thank you, sir.
we will hear you in question hour session also if there is any question. So, sir, thank you very much.
Thank you. Thank you.
So, our next speaker is Mr. Yashwant Dev Pawar. He is from the TIFAC, which is a unit of DS New Delhi, and he is presently the head patent facilitation center of the you can say TIFAC. The most of the scientists which are facing the problem how to file a patent application without if they don't have the funding. So PFC is the organization of a TIFAC which help scientists to file a patent application without charging any fee from the scientist, and also provide all sort of assistance to the scientist to file a patent application. Say, for example, if a scientist is working in ACRIP or DST project or DSIR project or any government funded project or private funded projects, he has a privilege to file a patent application, and all the expenses of filing the patent applications can be made out through the ACRIPs. But if a scientist is working his own without any source of funding, external funding, and he has developed some technology or some theory, or you can say anything, and he wants to file a patent application, then definitely he needs some funding. And in case of the funds are not available to the scientist by the university or any other sources, then he should not be disheartened, and he can, or the team can approach to the TIFAC and contact Dr. Yashwant Dev Pawar to file the patent application. So I think Dr. Pawar might be here. Pawar sahab, aap aa gaye? Are you here? Actually,
No, sir. No, sir.
Actually, he is in some another meeting with AICT chairman, Mr. Sesrodde. So he will join here within due course of time. I think not more than 5 minutes. So if any participant have any question regarding filing of a patent application, or he is here.
Yashwant Pawar, sir.
Okay, good afternoon. Sorry for being late because we had something else.
So, sir, I have given you a brief introduction.
Thank you so much. Thank you so much for saving a lot of time.
In your absence.
Thank you. That's good. We saved some time. So, should we
take session?
Yeah. So what I do is start sharing, but I need a sharing permission.
Yes, sir. Yes, sir.
Thank you. So, good afternoon to all, and I'm sorry being late, but it was just unavoidable. So I think you would have had good session. I joined the inaugural for about 20 minutes and heard all pros and cons of intellectual property rights described to you. Am I audible, I believe?
You are audible, sir.
Okay. So I think you had a very good introduction about different forms of intellectual property rights in previous lecture. I've been asked to talk to you with regard to what facilities are available in protecting IP from the different universities, different institutions. So not only I was asked to talk about facilities by PFC, but let's talk in a holistic manner. At the Government of India level, there are different facilities available, and what is their role, and what these IP cell or facilitating center, what kind of roles they have to play. Uh, so I think we had a lot of lockdowns, we had a lot of unlock, and again lockdown, and again unlocking. So many times in different places. So similarly, when we are unlocking from COVID pandemic, and let's assume that we will not have another locking, but the same way, if we can unlock intellectual property rights, will take us a long way in unlocking us from such a pandemic in future very quickly. As a government official, I should request you wear mask. I'm alone, so that's why I'm not wearing it. So wear mask, keep distance, and do hand washing regularly. So when we say during the pandemic, what great innovation or invention or innovative work was done to evolve intellectual, to have intellectual property rights. If you look at Arogya Setu, it was developed within a record time of few days. And you can imagine IP can be generated in a difficult time, difficult moment, and in difficult setting itself. So I think this corona could not have stopped you from innovating. So now this seminar or a national webinar, what you say is to let you know how to protect. Many of you are aware, but let's talk in detail. I'll just skip this all. So when we talk about patent is nothing but a deal between Government of India and the applicant. And applicant are universities, research institution, industries, in some cases, the people themselves. And the inventor comes as an inventor in the patent application. So it's a deal between the applicant and the government. In that particular deal, inventor discloses all technical details to the government. And in lieu of this disclosure, government grants limited monopoly, that is of 20 years, to applicant. And after that, it becomes a public knowledge. So no IP is for few individuals. It is for the larger benefit of public, because I saw that particular debate in the inaugural session, that harmful effects of intellectual property rights. So actually it is up to us, how do we manage and accrue benefit to the society from this IPR system. And it has to be seen in a holistic manner, not in isolated. Let's take a background. When we started this patent facilitating center, about which I was asked to talk to you, I correctly remember there were 4 patents granted in 1995 to 3 universities. In whole of India, there were only 4 patents from 3 universities. And total filing in India was about 3,000. And most of them were foreign entities, and few hundreds were there from Indian entities. It was led by CSIR and some industry and few individuals. From there, we have now graduated to next level where we have patent filing in India more than 50,000, though this is not comparable to few countries, but we are not very far behind also. So we have to take positives and negatives in a righteous manner and convert every negative into a positive aspects. When we started, there were only 72 patent agents, and most of them were inactive, and most of them were actually lawyers only, and not many were having scientific background. So it was very difficult to draft and file patent application. And then even amongst the scientists and university professors and stakeholders, there was less of understanding about intellectual property rights. In that particular time, neem, haldi, bangan, curry, etc., created a lot of awareness amongst Indian community, Indian people about intellectual property rights. So that was the background with this patent facilitating center was started. Later on, the global ranking started. We moved from 101 to 50 ranking, and I think we are aspiring to be in top 10 very quickly. But if we look at total filing in India, as we are at a 7th number, and not only behind of, but the question comes when we look into for higher education, this little old data, maybe 2-3 year old. If we look at this particular data, see, if you look at Korea, which is at a 7th number in Global Innovation Index. So this orange portion is actually is university ranking and average score. Or at least if you look at this Finland at a 10 number. So the three parameters on which we are ranked, university ranking score in top three universities, we are at par with these countries, Finland, Denmark, Korea, etc., even Sweden. If we look at the cited document H index, we seems to be ahead of many top rankers in global innovation index. But where we fail is see this yellow line. The patent family is filed in at least 2 offices, and the yellow line. This, if we see here, I can just give me a moment. If you look at this particular portion, we are not filing patents. So that's why we are ranked very low in global innovation index and quality of innovation. Whereas if we see in all, if we look at this particular portion of quality and this particular portion of H-cited documents, we are ahead of many countries who are top 10 rankers in quality of innovation at global level. So I think we have to focus on patent filing, and with this objective, in 1995, this patent facilitating center was set up with May We Help You approach, and to create single window facility means all facilities with regard to assessing patentability, understanding patentability, filing, prosecution, maintaining. So everything should be available through a single window. So this facility was started. And to reach out to remote universities, we conducted more than 500, 600 workshops in different parts of the country, in more than 200 plus universities in about many cities, 150 plus cities in the country, to make them aware. And I believe Udaipur also we have visited many times to make aware, and this Rana Pratap University as well. And we supported some of the invention, and I would like to acknowledge a couple of patents from Dr. Mathur, who is coordinating this event. And I feel very happy that the filing and grant of his patents are keeping his interests alive in the IPR system. And such an enthusiasm he is percolating down the line within agriculture system and Bana Pratap University per se. So thank you, sir, for keeping that tempo and momentum going with regard to IPR, and I expect many more IPR and patent filing will come through this. So, this center was established with fourfold objectives. First was to make people aware and create a culture of providing patent information as a vital input into the process of R&D. And on this particular objective, I always gives me a lot of pain that we have not succeeded as much as we could have been. And I urge you to look at patent information as you look at other literatures. When you do research, please do look into patent document, because about 70% of technical information which get published in patent document never get published in any other technical journal or any other document or in any form, publication in any other form, because in patent document there is an enabling disclosure with regard to that particular technology or invention. And then other patenting facilities, I urge you to use this facility which is available. We provide full financial and technical legal assistance in filing and obtaining and maintaining patents, and maintenance is for limited period. If some substantial work is done by inventors or applicants in product development and commercialization, then we support beyond a certain period. But up to grant, we extend full technical, legal, and financial support, and everything is handled by this center. And we also keep watch on different development across the globe with regard to IP, and infuse those inputs into the government policy making from time to time. I'll not go and read the fourth objective of creating awareness, understanding, and training people. So we all make a lot of efforts now. Not only PFC TIFAC, but very many agencies are making different efforts at different level in creating awareness, be it be CPAM, be it be NRDC, be it be MITI, and now universities on their own, institutions on their own, working on creating awareness. But here, two crucial points. We have to create culture of using patent information. So once researchers, teachers start using patent information in to their day-to-day work, then they will be more updated on latest innovation and innovative technologies in their domain. And whatever they would be inventing will not face challenges of novelty or inventiveness, because they are already aware of those aspects which are really required to ascertain patentability or protectability of any inventions or creation through patents or other forms of intellectual property rights. But the key is to create culture. And to let you know, this access is available free of cost on internet, so no charges. Even if you want to get access to journals and technical documents, you have to pay some time. But for patent document, you don't have to pay. All patent documents for in some of the countries from last 200 years, freely accessible through internet. So I firmly believe that you will take advantage of this technical knowledge which is available to you. And patent which has not been filed in India and filed outside country and granted, we are free to use in our country, free to use in our country for commercial purposes also. So it's all we have to see. But for research and teaching purposes, we can really use to sow these seeds. So these are the questions we address in the workshops, and I would like to throw some light how to recognize an invention. See, when you work in the laboratory, if you come up with any new thing or new technical effect by modifying device, by modifying process, and if you are able to see new products or a precursor of a new product for new application, so that excitement itself is in recognition of invention. And then really finding out what has led to this new effect, technical effect, or a new product. What has led to this? So documentation and understanding of those effects and costs is actually beginning of documenting those creative work or innovative work by you. So how do you proceed for obtaining patents, copyright, design? So what we do, we just don't bother our scientists to get into this, entangle them into this particular process of filing, prosecuting, etc., etc. So that's why what they can do is approach to us. So we will do patentability analysis, we will do protectability analysis, and we'll let you know whether it's to be protected through patent, whether it's to protect the copyright, or it's a subject matter of design, or any other forms of intellectual property rights. So there are certain principles of keeping and maintaining secret until the patent details should not be revealed. There should not be any publication. And beyond publication also, there should be appropriate mechanism to keep it secret till those patents are filed. So avoiding discussion, avoiding publication, avoiding covering those aspects which have for which patent has not been filed into seminars, workshops, trainings, etc., etc. But government reporting may not lead to a loss of novelty, because sometimes it is required by the law or the government. Those will not actually come against you. How do you keep record? That is also very, very important. See, because when some questions comes from patent examination, maybe from us, then we'll come back and ask you, does this work in within this range? So you need to have an appropriate records and authentic records to go and verify different aspects of those invention and come up with the right kind of argument during the prosecution. And then it is not that you can file patent yourself. You can file your patent on your own, but the right kind of protection would be possible if we are taking help of professional IPR attorneys who can really create a document and write claim in such a manner that we get a right yes and meaningful protection of our innovation. We may file patent on our own, and patent may be granted also. So it is always like you can go and fight your case in court of law, but you generally hire a lawyer. So I would draw analogy to that only. And then the patent search is a specific job, but I believe now all the researchers and the technologists should be able to do a basic patent search, not a detailed patentability analysis or landscaping or a big searches, but they should be able to look at conduct basic patent search where they can locate patents in their own areas and make a habit of reading patent documents. So that is to be done by. This is how we have facilitated number of patents from different. And at one point of time, about if you see 96, 97, almost 90+% patents were filed through our centers in whole of the country. And slowly we started setting up facilities and enabling many institutions. So afterwards, it was in 1998, we were filing about 80% from 90 plus. By 2004-5, this number reduced to 40%, and now we are filing about maybe 4 to 5% of total filing from universities or academic institutions. Can you give me a moment? So the role of PFC is to extend technical, financial, legal support, which I have already talked. All the expenditure with regard to this filing, granting, and maintaining is borne by TIFAC, other than cost of inventors' travel to attorney office, and to create awareness in seminar. So what is the mechanism? We receive request from inventor applicant, at least half a page write-up to begin with. Then we conduct a detailed patent search and assess the novelty. And then there is interaction between my officers with inventors on issues of novelty. Then it is examined. We examine ownership issues, whether there is a funding from any other institutions or not. Then once the patentability is established during these discussions, that include non-patent search, then we put up to the committee of IP filing of TIFAC. Once it is recommended by committee, we hire a patent attorney from our panel, and we organize inventor attorney discussion in drafting patent documents. Then we also file request for examination, and we take input once the examination report is issued. And we also take care of renewals for 10 years. And after grant, we have to file annual working statement. So with the help of professors, we do that. And then we go for the next process of technology transfer. So I'll not go into this. So there's the National IPR policy, which has 7 different objectives. Sorry, generation of IPR, etc., etc. So what we do? Let me see. There are very many facilitating agency, PFCS, TIFAC, NRDC for grassroots innovation, National Innovation Foundation. For Ministry of MSME, there's called Intellectual Property Facilitation Centers for MSMEs. PIS is now the training institute. All major institutions have their own IPR cell, and I believe your university should have IP policy and IP cell. This is a complete. So how do we focus on improving our IPR output? So there is a need and evaluation of publication for patentability before they are communicated to journals. So that's what the university administration will look at, and then rest of the thing can be left on to organizations like us. But there should be some encouraging mechanism for inventors to be created. Then it is to sign, if government link it with research funding, then it can spur further. And there has to be a mechanism to distribute those royalties with innovators, collaborator, inventing institute, and funding agencies, to whom we provide support to all academic institutions. So we are not differentiating between public and private institutions. So the government R&D institute, government funded research, etc., etc. So we have state patent information centers. We have one in Jaipur, DST, and they have regional offices through which also the patent facility can be accessed. So there are takeaways what these IPR cell need to do. They should interact with faculty members regularly. So we can provide them further support for workshop and training. They can coordinate with patent information centers and PFCs. They can be instrumental in IPR policy development in their institute, and they can also conduct an IP audit of the university, where they can scout the innovation and patent filing things. So there are a few people who are very important, this whole chain. There's inventors, facilitators, attorneys, and examiner and controller. So we have to understand every person in a loop to get patent granted. And these are issues, these are step-by-step process of facilitation agencies finding the problem, then distillating the idea behind the solution, comparing. So these steps we do and help our scientists and filing and obtaining patents. So this good patent would be not maximizing the scope of protection, but it is to optimizing the scope of protection. So that would I would edit this to that level. So it's nothing but an unleashing scientist's mind and converting into patents. And these are the basic features you should strive. It should be easy to defend, means clarity has to be there and claim to be supported by description when we are filing an application. Okay. So these are the agencies which supports patent filing at a different stages. So what is required and what, how and who will help? So if there are patent agent, if you can recruit the trademark agent, and then you can train scientists, but you should have access to different database, different formats, different analytic tools, and training to be given to them to really help by inbuilt facilitation center within your organization. And then we can launch these inventions through technology transfer into the public. I think I'll stop sharing here. If there are some questions I can ask, because I have been called for a few other things. So I'm really sorry. Because my Dr. Mathur, am I audible? Dr. Mathur?
Yes, sir.
Yeah.
Yes, sir, you are.
Yeah. I think this
I
is
want-
what I wanted to share, because I'm in a little hurry because I'm getting calls and reminders to be present somewhere in office at all. So
So if you want to,
there are a couple of questions I can take.
so any questions from audience? Is any specific question? I can say any specific question.
Sir, I am sharing some questions.
Yeah.
How to take more claim for the existing patents?
See, there has to be, if you have already filed a patent and if you have a claim, so that patent is closed. So if you want to file another patent with a new and further improvement on that, so there are two options to you. You can file a patent of addition, or you can file a separate patent or new patent for the improved technology. So in each patent, you are allowed maximum 3 independent claims, but you can have n number of claims depend on different embodiment of your invention. But
One question from
go in a patent of addition as well as a new patent. Yeah.
one question from Rajan Sharma. A research
Yeah.
at our institute has identified on new protein in urine
Mhm.
of dairy animal which can be used for the particular physiochemical conditions of the dairy animal. This
Mhm.
protein can be detected by already known method.
Mhm.
Can patent be obtained for novel protein?
No, see, this novel protein is existing in urine, or it is has been modified, created. So if it is,
As
it's a,
written in a message, it's a new type of protein. A
so
new
if it
type,
is
new protein.
what I understand is a discovery of a new protein which is existing in urine. So discovery may not be patentable. But if you create a new mechanism of use of this, or the method of isolation which is new, that can be.
Yes, sir. One more question.
Yeah.
Sir, how much is the maintenance fee of your around and how much for patent?
See, if it is processed through us, then there is we will pay all the maintenance fee. We will pay all official fee. You don't have to pay anything. But if it is you are directly doing it with patent office, so from third to 6th year, that's about 2,000 or 4,000, and then every exceeding then 7 to 10 year the different fees. So then it increases. It goes up to 30 more than 50,000 also per year. So it depends on later stage. If commercialization is happening, then you can decide to renew beyond certain period.
One and last question. How to counter the situation when someone posted a video on social media before filing the patent of the technology?
The video will kill your patent because that will be a prior knowledge. So it should not be posted and it should not be disclosed in the public. Because the patent office will show your video that your invention was disclosed prior to patent filing by you. So after filing a patent, you can do that.
Sir, there is one request from my side.
Yeah.
Whenever these things become normal and whenever you have a chance to conduct any workshop of
Yeah.
IPR, please keep it mind MPUAT to conduct a workshop. Because conducting session of 1 and 2 hours will not serve our purpose fully, but conducting a workshop with some hands-on training type of things, it will be very, very beneficial for all of us.
Sure. I think I should ask DST Jaipur to further support you in this through our center, and then we can organize people for you. No issue.
Thank you.
So if there is no other question, I'm really sorry because I have to rush.
Okay, sir. Thank you, sir. Questions over.
Thank you very much, sir, for sharing your valuable views with us. So thank you very much, sir, for sparing your time.
Thank you.
Thank you, sir.
Thank you.
Let us be grateful to people who make us. Let us be grateful to people who make us happy. They are the charming gardeners who make our souls blossom. Marshall Proust. So no event is complete without gesture of gratitude, as gratitude is not only the greatest of virtues, but the parent of all the others. So at the end of the session of today's webinar, I request Dr. S.S. Meena, PI Akripon ISA, CTA, to please propose the vote of thanks.
So just a minute. If anyone has any question before this vote of thanks, he can be asked any question if he has any question, please. Or you can write your question and mail it to us also. No problem. So Meena sir, please.
Namaskar. Good afternoon, sir. Is it audible now?
Yeah.
So, Honorable Vice Chancellor, sir, and Chief Guest of this program, Dr. Narendra Singh Rathore Sahab, our special guest, respected C.R. Mehta Sahab, Director CI Bhopal, eminent speakers, and valued participants, conveners and co-conveners of this program. It's my privilege to have been asked to propose a vote of thanks on this occasion. So, in this regard, firstly, I wish to like to thank our Honorable Vice Chancellor Sahab, Patron and Chief Guest of this program, Dr. Narendra Singh Rathore Sahab, for giving us time even under a very busy schedule. Sir, we are thankful to have such kind of dynamic, visionary, and a motivational leader with us. You always encourages us to do something more and more so that our farmers, our students, and researchers will get benefited. We are really fortunate to have you with us. Thank you once again, sir. I assure that your valuable suggestions will be taken care of. A big thanks to our special guest, Dr. C.R. Mehta Sahab, Director CI Bhopal, for his effort toward the need of IPR in agriculture machinery innovations. As you are the PC of this FIM, sir, and sir, you are rightly said that there is a strong need to promote intellectual property, to protect intellectual property rights of the innovations, which can be achieved only and only by creating awareness about the IPR. Thank you, sir, for your love and affection to the CTI, especially as you always ready for any kind of help to this institute. I must mention our deep sense of appreciation for this eminent speakers, Mr. Rajan Alawadi, sir, IPR attorney, CILEIT, Intellectual Property Council, Gurgaon, for your beautiful explanation of the patent filing process. Sir, it is true that someone is required to show the path and you are here for the same. I hope that all the participants will get benefited from your speech. Thank you, Vasangai, sir. I also thanks to Dr. Yaswant Dev Pawar, sir, scientist and head PFE of TAFIC, New Delhi, for explaining the role of TAFIC in patent filing to the university scientists, innovators, and students. A proper documentation is required for patent filing, and your support for documentation without taking charge is really helpful for us and our innovators and scientists of the university. I may likely to express our sincere thanks to Dr. H. Sharma Saab, Director, Research, MPUT Udaipur, for organizing such a kind of wonderful program. You always give emphasis to do more research, to develop suitable technologies, innovations, so that our farmers get benefited. Sir, I also wish to express my gratitude to our Dean, Dr. P.K. Singh, sir, for providing venue, support, encouragement to organize such a program. Sir, it is your vision that our research students are doing a good quality of research and they really need to have such a kind of program. I assure that all the students, scientists, and participants of this program will get benefited. I would also like to take this opportunity to place on call our heartily thanks to Dr. S. M. Mathur Saab, Emeritus Professor and PIO PICRP on FIM, for working day and night to frame such a wonderful program. Sir, our students face problems due to lack of awareness about the patent filing. This program will make them energetic and aware to protect their intellectual property rights. I also extend my thanks to Dr. Nepalia sir, Viren Nepalia sir, technical advisor to Honorable Vice Chancellor sir, and coordinator of this webinar for continuous encouragement and making coordination with officials of the university to make this program successful. I wish to give special thanks to Dr. Hemu Rathod Madam for beautiful commencement of this webinar. Further, I wish to thank to Dr. Manji sir, Assistant Professor of and 4 PFC member, for creating and managing the online portal for a smooth running of this program. Sir, really your management for organizing this online webinar is wonderful. Thank you, sir. Well, thanks is not a sufficient word for the persons who made this program to great success. And these are the participants who joined from different parts of the country. Because without the participation, the program will not be completed. So thanks to all the participants for listening the program with keen interest. I hope you all get benefited by this webinar. I can't thank everyone enough for their involvement and their willingness to take on the completion of the task beyond their comfortable zone. So thanks to all for creating, managing, organizing, and making it a great successful for this program. Thank you all.
Thank you, Dr. Sawan Singh ji. With this, we end with today's webinar. Hope you all will take home a lot and start doing something for your achievements in IPR. Stay safe, stay home as far as possible. Thanks to all once again. Jai Hind.
Thank you, madam. Now I am request to HVC sir and designated experts. Can we close the session? Okay. Now I am closing the today session here. Thanks to one and all.